This panel is, after having seen now the big picture of the importance and some of the threats to the coverage of the courts, we're going into the trenches now. And we're going to do it on both sides, both the reporting side and the public information side of it. Starting off with the reporting side, we did find one of those general interest reporters, Howard Mintz, from the San Jose Mercury News. I've known Howard through his writing for many, many years. I tried with my colleagues back in California to compete with him to no avail. An outstanding journalist. So he's the speaker on the general interest side. We're very fortunate to have Alan Pusey, who's the editor and publisher of the ABA Journal here. It's the largest circulating publication for lawyers out there, and also a former employer of mine. I've actually had the privilege of working with Alan, but it holds a very unique place. So he's going to speak to coverage of the law from the standpoint of this niche area of journalism that we call legal journalism, or as they prefer at the J School, legal affairs journalism. Why do I say that? Because when I first came here, nobody had heard of the topic of legal journalism. Over at the J School, they never heard of it. And so when I explained what it was, they said, well, we don't like that title. And I said, what do you mean? They said, well, it implies that there's an illegal journalism. And I said, you're kidding. No, we're really serious. So we're going to call it legal affairs journalism. And so with no further ado, you decided on an order? Or?
I'm going to go first.
Okay, great.
I guess it's only appropriate I go first because given Gene's remarks, I guess I'm the rare dodo bird.
T-Rex.
I would like to know where this long runway is, though. I've not heard of the long runway because I work for an organization where the runway is sort of like a little helicopter pad that you land on every day. I would love to hear more about the long runway. I'm going to focus primarily, I've been covering law, legal affairs, whatever term you want to use, for over 25 years. And I'm going to focus primarily on kind of the evolution and the transformation of how we do business, how we cover what we cover, both in terms of our methodology and what we face today, and the change in the courts and the technological differences that exist today versus when I started out. I mean, I'm going to go backwards, but this is a major change. This morning, I got up, opened the email, and one of the cases that I've been covering for the last year and a half, 2 years, is a patent case between Apple and Samsung over the rights to the technology to these devices. Billions of dollars, between the two. I think Apple just disclosed it already spent over $60 million on lawyers in the case. And I awaken every day, and probably while I'm talking, to email alerts for everything that's filed in the case, which clutters my email unbelievably. There were a couple of things filed this morning at 12:30 a.m. When I started covering courts in the late 80s, nobody was filing anything. Lawyers may have been working on things at 12:30 a.m. I'm sure they were, but they certainly weren't filing things at 12:30 a.m. That's, in a nutshell, where we are today. Just a little bit about what I do, because the biomaterial is there. I've been with the Mercury News since '97. I cover most of the kind of atmospheric courts in our area, the Ninth Circuit, Federal Appeals Court, the Bay Area Federal Courts, the California Supreme Court, State Appeals Courts, and all the issues that cross through the paths of those courts. Prior to that, I worked for The Reporter, which was a legal newspaper in San Francisco, and kind of honed my skills a little bit on covering the law in courts. As Gene mentioned, it resonated with me because I started covering courts for a small paper in much the fashion he described. I was in my 20s and, kind of worked my way up and bumped an old guy out. So, now I'm one of those old guys, I guess. But,
and about to do so again.
And the advantage, and we were discussing this last night, of having worked for about a half dozen years for a specialty law publication, is that the audience was judges and lawyers, and it forced me to become more sophisticated about the way I cover law in courts. You just have no choice. That's been something that has helped me when I've gone back to general media. I do not have a law degree. I get asked that constantly because when you write about this stuff for as long as I have, that becomes an obvious question. I do not think you need a law degree to be a legal journalist. I'm sure it doesn't hurt. I think, there may be times, I suppose, it probably clutters the journalist mind when you're in that half of your brain. I don't know. Maybe we can discuss that. There's a lot of great lawyers who become great journalists. Where we were when I started covering courts was paper and people. You would go to the local courthouse and you would beg a court clerk for the court file. If a judge came out with an opinion, somebody would have to hunt it down somewhere in the courthouse, or you could go to the judge's chambers and beg for a copy that maybe you could get in time to write for the next day's newspaper. The idea of technology, when we went into the courtroom for a trial or a hearing, it was, just the notepad and pen. The idea of a laptop was, space age. Fast forward to where we are today. Everything's about immediacy. Everything's about now. Back when I started covering courts, obviously there wasn't posting the internet, there wasn't Twitter, excuse me. It was about polishing a story for the next day's newspaper. And your only real concern from timeliness was maybe television news, and they were pathetic covering courts and legal system then, and not much better now. I guess that's why I quarrel with the idea of the comment that there's increasing public stupidity about the court system. I'm not sure it's any different today than it was 10 years ago. But you were on deadline, there was immediacy, but it's nothing like what we've seen in the last 5-6 years. It started before that, and Mercury News had a website. I think it was one of the first, if not the first, and we did a great job monetizing that, as you can tell by our shrinking newsroom. It's really been about the last half dozen years that we've seen this explosion of, having to have it now. It's not unique to legal news, but I think both the opportunities and the competitive nature of legal news now separates it a little bit from a lot of other areas of journalism. There are a lot of great opportunities there, but we're in a push-button climate. It's got to be now. It's got to be fast. We're flying a little bit without a safety net. There are editors, but I can tell you that when a court opinion comes out from the Ninth Circuit of the California Supreme Court, and I digest that and I spit out the result, that first iteration of what I put online doesn't have a lot of eyeballs on it other than mine. I'm not a great fan of editors, but that is a little dangerous, but that's the reality. And I think we saw it a little bit, as I recall, with the healthcare decisions 2 years ago with the Supreme Court. The complexity of that, it didn't trickle out quite the way the decisions came out. And I know that when I covered and I'll get into some specifics of these cases, I covered the gay marriage cases out in California and the DOMA case and using the U.S. Supreme Court. And I had a funny feeling that the Proposition 8 case, which is California's voter law that bans same-sex marriage, that would be decided on a standing issue. And that editors, that makes their head explode. What do you mean? People get married the next day, that's all they care about. I said, is, I'm gonna need to read this, so if we aren't first, but that's where we are today. The way courts are dealing with that has improved dramatically. I can tell you that the federal courts, as I say, everything's electronic now with Pacer. So I literally, if something is filed in a case that I'm following, I have access to that immediately. The days of hunting and searching for documents are pretty much over, at least in the federal system. In our state court system, the state trial courts are still kind of languishing in about the year 1997 or something. Even in the courts of Silicon Valley were a little slow. The higher courts have gotten very good. The California Supreme Court, again, this is when I started, you didn't know necessarily what days they were going to come out with opinions, what times, and they lay a stack out for reporters and go find them. Now, it's Monday, Thursday at 10 a.m. They're going to come out with opinions. The day before, they have notice of filing, so if it's, people versus whatever, and you're filing, it the day before, you can prep for it. That's just enormously different. And some of that is a product of exchange between journalists and court over time about ways that they can accommodate us. The Ninth Circuit, as big as it is, 10 o'clock every day, opinions are up. And if you're getting Pacer alerts, you need a little bit more of a jump as the case you're following. I'll get into the in the courtroom element, but that is a big change. That it seems simple now that you can have access to this kind of information fairly quickly, but it was not always the case. It was not always the case. The second component of that is inside the courtroom. For journalists and tools, the biggest change is that, there are a few dinosaurs I know out in California that still bring the notepad and pen into the courtroom. And my experience with the U.S. Supreme Court this year, or last year with Proposition 8 and DOMA cases, I was surprised they didn't make us write with quill pens. It's just another universe that I just didn't understand. But the Ninth Circuit, for example, which is only a step away from the Supreme Court, was a big step. Laptops, cell phones, as long as the audio's off in the courtroom, not an issue, don't have to ask for it. It's just the way they do business. I don't know how the other circuits are. As the Eighth is this circuit. I don't know how they are here, but the Ninth Circuit's been good. They're now starting to webcast arguments. It's something you can take for granted, but when you have a judge that, my time up? When you have a judge who doesn't accommodate, it's a different deal. In the Northern District of California, our federal judiciary, generally speaking, the judges allow electronics in the courtroom. I have covered 3 major trials in the last several years. The Proposition 8 trial a few years ago in front of Ron Walker, the Apple Samsung case in front of the judge of San Jose, Lucy Coe, and the Barry Bonds perjury trial, which was a big deal in our neck of the woods, and probably made the Cardinals fans here happy, in Judge Hulston's court. And all of those were instances where there was a very large media presence every day. We worked things out with the court beforehand, and there were no problems. And in the Barry Bonds case, you had sports reporters. I love sports journalism, but you put them in the courtroom, you never know what's going to happen. So, but we have judges who don't allow it. There's 2 kinds of judges in my view when it comes to technology in the courtroom and media issues. There's enlightened and not enlightened. It really is a matter of education. But we still have judges in our district, and state court judges are probably the worst, who will not allow electronics in the courtroom. And that's very difficult in this day and age. because of that immediacy factor. We in general journalism right now, we're competing against other journalists, we're competing against bloggers, legal blogs, they're everywhere. And there's some very good. I mean, SCOTUS blog has become a modern phenomenon. Again, unimaginable just a few years ago. But you look at how indispensable that site was in the last 2 terms of the Supreme Court. It's amazing. All this immediacy, if I have a few minutes, all this immediacy is a great opportunity for us. It's opened the door to huge audiences. I mean, when I covered the Proposition 8 trial, the best thing that happened to me is the Supreme Court overturned Judge Walker's order allowing, he wanted to broadcast it on the web. The Supreme Court said no, and the best thing that happened to me was, and I blogged that thing all the way through, we had numbers off the charts that may not have happened if the Supreme Court had allowed them to broadcast that. The danger here, though, is that for me, a lot of what I've done over the years was to try to also cover these institutions with some substance. I've written a lot about the death penalty in California and, just issues where you can train your eye on the justice system in a way that you spend time on. Just to wrap up, when I joined the Mercury News, they cut 4 of us loose for almost 6 months to follow a group of local criminal court judges who were taking off regularly on Fridays to play golf at a time when our local criminal courts had an unprecedented backlog. And we spent a good 6 months just following those judges to golf courses and documenting it and doing it the right way. And today, there is just no way, and a photographer, by the way, the pictures are awesome. There is no way today, and I'm sure if my editor was here, he might quarrel with me on this, but there is no way that they would cut us loose. 4 of us, there's no way. And what's lost in all this sense of immediacy is I don't know if the numbers are as grim in terms of reporters not covering the courts, but I do think while there are great exceptions around the country in terms of training an eye on the justice system and doing things that are more in depth, that's going to get lost a little bit because we're too obsessed with making sure we tweet out what happened today. So with that, I guess I'm done.
Next speaker is Alan Pusey, who's the editor and publisher of the ABA Journal. One thing just to note, a good transition, what you heard from Howard was a good example of investigative reporting. I'll bet that story played very well.
Well, except for a few of the judges.
Except for the judges, right. And in his previous life, Alan actually worked as an investigative reporter for many years for the Dallas News. So that's not why he's here. He's here because he is helping to shepherd maybe the most significant legal publication through a new generation.
Well, thank you for that introduction. I come up here I was going to give an optimistic sounding address, but I've kind of been dissuaded. And maybe the best way to put this in context is to talk a little bit about all the things. I've heard 2 things, an incredibly depressing presentation about the state of the business right now, and then the use of the word opportunity in Harris talk, which I kind of agree with both. I mean, that's the dilemma that I have in speaking to you today. I've been a reporter for more than 40 years, actually, about 45 now. I started in 1971. So in many ways, I've seen the arc of journalism, from its pre-Watergate days all the way to whatever it is now. I started in journalism very hopeful. Watergate made it cool to be a journalist. And then finally I ended up, or I thought I was ending up, by taking a buyout from the Dallas Morning News after 26 years. Honestly, I thought when that happened that I was going to have to find something else to do for a living, because I didn't see much of a place for me, an older guy who was unwilling to wear a hat with a webcam on top, around to small news events and the hyper-local coverage, the way things were developing. And so, you know, I trailed off and was a pretend freelance writer for a while. So finally I had to look for a job, and I found one at the ABA Journal. It had a couple of things I really liked. A, it was a print publication, and I could stay in print and do what I cared about most. And secondly, it had a captive audience. The ABA Journal is the publication for members of the ABA. So members of the ABA, as long as they pay their dues, they get a copy of the magazine. So I had a built-in circulation of about $380,000. $380,000. And that really made me feel like I could be comfortable for at least until the time I retired. And I think that's an important aspect because personal experience over time showed that the news business was changing in rapid ways. I thought I wouldn't have to change, but now I stand before you and I've changed incredibly. I've become more optimistic about the business. I see more opportunities. And I think that in a lot of ways, what has happened is that we've had maybe not so much a change in the fundamentals of journalism and the fundamentals of what people are looking for in journalism, but a change in the business model. And we're trying to adjust to that over time. And anybody who thinks or tries to tell you that they know what that business model is right now, I think they're either delusional or they're lying to you, because I think we're all just sort of feeling our way. And as a result, I think it makes us do some things that look really dumb. It makes us do things that look really shallow, but I think it's a balancing act where you lean one way, then you lean another way, but the object is to keep your balance and to keep yourself moving forward. The death of newspapers is, or at least the sickness of newspapers is well chronicled to depressing extent earlier. I think the number of daily newspapers, for instance, has declined about 300 since 1985 or so. But they're still there, okay? And I think that's important. They're surviving by doing things like go hyper-local, and that I think has created a lot of the situations that we're talking about, where you try citizen journalism, you try to have everyday people sort of contribute to your newspaper. But I think that experiment has been problematic, and I think the value of that shows up in other ways that we'll talk about in a few minutes. I think the other thing that I guess I've come to realize is that now the legal profession itself is in kind of the same situation that is familiar to me as a newspaper man. I'm not a lawyer. And like Howard, I don't believe you need to be a lawyer to cover journalism. You're not a cop, but you can cover crime and that sort of thing. I think it allows a certain perspective on the law that you might not have if, in fact, you are a lawyer, or at least a practicing lawyer at the time. There are many lawyers who are marvelous journalists, and I'm not knocking that. You know, I think you don't have to be to have insight. But one of the things I've noticed about the business per se of being a lawyer, and I think this is important, is that their world is changing too in many of the same ways that newspapers have. You have a lot of the clients for the larger firms who are, I'm going to go a little bit inside baseball here, but I think it's important. A lot of the clients for the larger firms are demanding cheaper prices. They're demanding that their legal fees be much lower. They're looking for ways to ameliorate the problem of the billable hour, which has been the lawyer's version of owning the printing press that makes money for a long time. There are a lot of sort of macroeconomic pressures on this too, aside from the clients and the clients demanding. Clients are doing specific things that are affecting the bottom line for a lot of law firms. A lot of the larger clients, for instance, are sort of pooling their resources together. They're pooling their the research that they pay for to each other through organizations that do things digitally, back and forth. They're outsourcing. A lot of the things that lawyers, particularly younger lawyers, used to be able to do in order to pay their incredibly expensive, incredibly expensive law degrees. And it is due diligence and contract review and that sort of thing. A lot of that's going overseas. We've written a lot of that. A lot of that's coming back too. They're not only doing outsourcing in Mumbai, I think they're doing outsourcing. AG is doing outsourcing in Wisconsin as well. A lot of exotic places. Law firms now too are suffering from their own business model in much the same way that newspapers have. They got used to making lots of money over time. They got used to a certain level of profitability, and in order to maintain that profitability, a lot of law firms have gone into significant debt simply to pay off the profits that they were used to. They've created this sort of top-heavy model where most of the money goes to a lot of the partners, and a lot of that, since it's debt, has become too unstable for a lot of law firms. And you get huge firms like Dewey and McGrath very recently, who are their own reckless financing is causing them to fail. I think in a lot of ways the same dynamic that influenced newspapers before are affecting lawyers, even the ones who practice on smaller levels. A lot of wills and a lot of probate items and other things are being commoditized, they're being digitalized and sold or given away on the internet. So Main Street lawyers with solo practices are having to compete with the internet as well. So the market is changing for them, and I think in the same way that we in the news business were slow to recognize that, I think lawyers are very slow to recognize that too. And it's one of the areas that we've grown to like to talk about. The whole quality, switching back now to the journalism business, I'm one of the reasons of my source of optimism is my own personal experience. I started in the business back, as I said, in 1971. And I was qualified for a couple of reasons. Number one, I was able to type on this clumsy Underwood typewriter without making the keys stick. And I was willing to work really, really cheap. So I got a job in El Paso, Texas, at the El Paso Times. The El Paso Times was a privately owned newspaper at the time. At the time I was hired, and the owner's son was the managing editor. He was an alcoholic, and the guy who sat next to me covered City Hall, and he was a friend of the alcoholic son and a former race car driver. So he had all those qualifications to cover City Hall. And the one lawyer on the staff was our political reporter, and our political reporter supplemented his income by getting appointed cases in the courts he was covering, and by writing the responses for the politicians he was covering for the news items that he was putting in the paper. So It was kind of an old-time corrupt atmosphere. There were a couple of things, and as I look back on it now, that were important to remember. First of all, the legal reporting per se was of two kinds. Number one, you had this classified area in the paper that was devoted to legal notices. These are, you're announcing your divorce, or you're suing somebody, or you're announcing purchase of some land or something like that. And this was public laws governed the fact that you had to do it. It was classified, and it was also a matter of patronage with the local, with the city council or the local commissioner's court. So a lot of times there would be some concern that if you covered the commissioner's court too closely and too vigorously, that they would somehow lose this very lucrative part of the classified ad business. The other part of it was that there were two places the police, police offices, the jails, and the courts were the two best places to develop content for the paper. Those filled the pages. So you had the money coming in from one part of the legal side, and you had the content coming in from the jails and the courts. These are great stories and great places to be a newspaper person. And I covered, my very first job was covering the courts. And I came to believe, and still believe, that the courts, the police station, and sports locker rooms have produced some of the greatest journalists that we have in the country. And the reason for that is that this is the nexus of a lot of human life. You have pain and conflict. You have hopes and broken dreams. You have real life consequences happening in all of these various places. And you get to write about it if you can see it and you can humanize it. And I think that's probably one of the most important elements that we can bring to any kind of coverage that we have, that any kind of writing that we have, is to take what seems problematic, what seems like simple conflict, and make it into something that is a human drama. And that's what we look for in our magazine. I thought I could use that.
Excellent.
Thanks.
Thank you. We have time for just one or two questions? Yeah.
Yeah, just trying to put maybe a more optimistic spin on things. Howard, by the way, you guys crossed paths years ago. I'll catch up with you a little bit later.
That's my brain.
But when you talk about how we went from paper and people to now Pacer, it's not necessarily a bad thing. And I just wanted to maybe put to the panel the idea that because of a lot of this technology and these efficiencies, that one, you can cover a lot more ground, and also you can go a lot deeper and do a lot more sophisticated reporting than maybe we were doing back when.
I would agree with most of what you're saying. I mean, there's no question that access to information is easier. I mean, both in terms of things like Pacer. I mean, I can Google a case, if somebody tells me, oh, there was a case in 1989, you can just Google it, find it, you don't have to go to a law library or anything like that. So in terms of that sense, there's more information, it's more readily available. The only part that gets lost is and I'm guilty of this, I mean, you don't engage with people as much and find out about things that are not on just a court filing. And you lose something there because you're not taking the time and don't have the time because of the lack of resources and the demand, give us more, give us more, give us more. And now, So it's a little bit of a trade-off. I mean, there is no question that it helps to have access to so much information easily.
And more than that, I think the technology allows a different experience and just sort of a drill down experience for the reader. They can start with a tweet and go directly to a story. They can find the story, they can find the background of the story or the court document beyond that. They can read as much or as little as they want. And I think that's an important thing to remember, that these things can be tied together.
In the back and then over here.
I talked to Randy Smith, who teaches at the journalism school here, and made the same point that you made about the lack of newspapers being able to invest in really significant investigative reporting. He talked about his work on the Hyatt Hotel collapse, which he said nowadays the newspaper wouldn't be able to invest as much time and energy in that kind of investigation. Similarly, Maurice Pusey and the guys at the Chicago Tribune who did such important investigative reporting, I talked to him, he said no way could the Chicago Tribune invest that kind of money in the kind of serious investigation he and his colleagues did of the criminal justice system in Illinois, which in fact, I would say his reporting led to a lot of the very positive changes in the system. Given the fact that we are losing that kind of investigative reporting, is it going to be replaced by bloggers and others? Do they have enough depth to be able to affect the kind of positive changes that were a result of that kind of investigation?
Bloggers don't affect positive change, period, because all they do two things, and there's some very good ones, but they're either aggregators or they're people sitting around in their pajamas popping off. They're not going to do what the Chicago Tribune did. You know, I'm very familiar with that death penalty work. I mean, that was amazing stuff. It takes an enormous amount of time and money to do those kinds of pieces. I mean, it's just a fact. And they're going to get done, but it's already fewer and farther between. That's not confined to legal journalism, it's of any kind.
Yeah, there's a rise of a new kind of organization too. You have the foundation-funded organizations that are taking on. I was on the board for 19 years in the Center for Public Integrity. And what we did was we created an investigative reporting model that tried to fill that gap. And, you know, that was, we were worried about it 20 some years ago, so.
Quick question and then we'll go back.
So I just have a question for Alan, and let me start by saying, the ABA Journal is really good. I was reading it on the plane last night. It was full of valuable, deeply reported, well-written, tightly edited, and confrontational journalism. And my question is, how do you do it, given that you are, in essence, a house organ for a trade group?
One of the second half of my talk, which I guess will show up in the written thing, is talks about the organization, what happened. And it was the same kind of, it was exactly what you're talking about for a long time. In 1984, they changed the model and changed the charter of the publication itself to make it an independent journalistic publication. I think it took a long time for the habit of being that to set in. But we have an independent board of editors made up of volunteers that have some very esteemed, Ken Starr was one of them. And what we do is we try to, it's not just confrontational, but what we try to do is confront the issues that are actually roiling inside of the ABA itself. It's a huge organization, and it has lots of disparate opinions, and we try to reflect the disparity of those opinions. And thank you for that. My staff is going to be so happy.
Before we take our break, let me just let everyone here know that these are all works in progress. So to the extent that you've heard something this morning, that you've got some feedback for the presenter, we're all going to be memorializing these in a written tribute to Tony. They'll all welcome this feedback. We'll be back here at a quarter after.